A Lei 13.853 de 2019 conferiu a redação vigente da Lei Geral de Proteção de Dados e instituiu a Autoridade Nacional de Proteção de Dados, configurada como agência incumbida de editar normas e fiscalizar o cumprimento da LGPD. Decreto promulgado em agosto de 2020 deu forma ao novo órgão. A Autoridade Nacional de Proteção de Dados, a ANPD, será composta por um conselho diretor, 5 membros indicados pela Presidência da República, Conselho Nacional de Proteção de Dados Pessoais e Privacidade, 23 membros, representando órgãos públicos e da sociedade civil, corregedoria, ouvidoria, órgão de assessoramento jurídico e unidades administrativas e especializadas. Há controvérsias antes mesmo da agência entrar em efetiva operação. A ANPD não poderá cobrar taxas pelos serviços prestados, o que representaria a possibilidade de projetar-se maior autonomia ao órgão. Como ocorre com todos os órgãos da administração federal, a exemplo do INPI, seus custos deverão estar previstos no orçamento geral da União. Mas, à diferença do INPI, não haverá arrecadação própria da ANPD, que sirva de base para o orçamento a ela alocado. Foi também vetada do projeto original a obrigatoriedade da revisão, por pessoa natural, de decisão tomada por algoritmo, o que, de fato, poderia prejudicar negócios baseados nesse tipo de análise. O fato é que todas as empresas que coletam ou armazenam dados pessoais de quem quer que seja deverão observar a LGPD e estarão sob a supervisão da ANPD quanto à sua observância. Aquelas que não estiverem conformes correrão o risco de sofrer sanções da ANPD, que poderão, em muitos casos, impor multas e até mesmo inviabilizar as empresas em decorrência da publicização da eliminação de dados pessoais imprescindíveis ao negócio. Neste painel, conheceremos mais sobre a LGPD e a ANPD.
Bom dia a todos, bem-vindos.
Good morning, everyone. Welcome to panel number 7 of the ABPI International Congress. We're going to be speaking of the National Agency of Data Protection and the implementation of the LGPD. The privacy topic is not a novel one, although it's in the media all the time. It's not novel. This started in 1890 by authors of publications of Harvard Review. If we look at privacy, you will have to look into the relationship of technology progress and the evolution of legislation. In the 1970s, new legislation started to emerge on the topic. The first article in the 1800s was written in connection with cameras, new cameras, allowing newspapers and tabloids to publicize pictures. This led to a great debate as to the violation of privacy. In the 1970s, other legislation came about to reflect the concern of society as to computer processing of data. There was a census at the time, and there was a huge amount of data collection on the population in general, and the capacity of computer processing of the personal data generated a number of concerns. So in Germany, in Sweden, in France, all in the 1970s. Today, we are faced with new innovation in technology. Given the internet that has been around for a few decades, and more recently, the speed of data processing and the capacity to store data. they are so huge that it has been coined big data. So this huge amount of information, data, and the way we interact with internet, which became from passive to interactive, and internet where we create content and we directly publicize data on the internet. So all these elements led to the use of data by organizations, governments, and so on. And that use has to be regulated somehow. In Europe, in 1995, there was a directive establishing the pillars for personal data protection. And in 2018, the GDPR, the General Data Protection Regulation, was enacted and inspired the LGPD enacted in 2020. The Brazilian LGPD is inspired on the GDPR, but it's not as detailed as the European GDPR. GDPR has over 270 articles between the preamble and the body of the law. It's not the case of LGPI. It brings the same rules, but it needs regulation. So this gives you an idea of the huge work on behalf of ANPD, producing rules and standards, regulate data protection, and also has the mission of changing the culture in terms of data protection. This is going to be a huge job to be carried out by the ANPD. I would like to then thank the president and the coordinators here today, and thank you for having accepted our invitation, and tell us how standards and enforcement of LGPD is going to operate. The first one is going to be Chairman Valdemar. Valdemar is an electronic engineer with a degree from the IME. He has a post degree in the University of Brazilian. He has been a professor of a number of institutes in Brasilia. He has been chairman of Telebras, and currently he holds the position of chairman of ANPD. Thank you so much for your presence, and you have the floor. Good morning, everyone. Initially, I'd like to start by thanking the invitation made by ABPI. We are going to celebrate 10 months of existence. And at this point, conversations, debate is very important. This is a very highly innovative but complex legislation, and still not very well known by the population and data subjects. I would like to congratulate ABPI for having chosen this topic. I think it's quite timely. The 1st of August is when ANPD is 100% operational, with now the capacity for sanctioning. I'd like to greet the panel, Felipe, Renata, Isabella, and Fabricio. I think we're going to have a highly intense as well as clarifying morning as to the LGPD. I have mentioned 10 months, and we have already mentioned a number of deliverables, successes, events. Not even the most optimistic person would fathom the possibility of producing so much to society in such short period of time. It's very different when you start from scratch. I used to work at Telebras. It had been around for decades. You just need to adapt, and it's some kind of continuity of the work. Us at ANPD on the 5th of November, we were 5 directors and nobody else. Today, we have 44 employees working at the agency. Our constitution is very lean, and we offset this by having hired highly skilled professionals, highly experienced professionals who deliver high productivity. It is highly challenging, however, rewarding, given the team we have managed to put together and given the work we have managed to develop. Starting from scratch may have some disadvantages. However, it does have a lot of advantages too. We can be inspired by other agencies and authorities around the world and decide what solution is best, what has happened in terms of success, and avoid mistakes made by others.
A importância do assunto para o Brasil salta aos olhos.
The relevance of this topic for this country is quite visible. We are a country that respects data privacy. Countries have their own legislation that have been. This law is a result of 8 years of debate at the National Congress. The legislation has been highly inspired by the European GDPR, but it considers our environment and our particularities here in Brazil. It is very rewarding to see one success after the other at the agency. Now, we have the National Council of Data Protection, 20 members representing the whole society, all sectors of society that are going to help us in this struggle, aiming mainly at a change in culture. We all know that a change in culture is not something that will be operated in a short period of time, but our objective is to accelerate it. The European GDPR was enacted in 2016, and it stems from directives that started way back in 1985. So 2 decades of privacy, respect of privacy culture, and respect to data subjects. We are starting now, and we're starting with a general approach. We have large organizations, we have startups, we have small and medium-sized enterprises, and many of them are very scared as to what to expect from the LGPD. When it comes to enforcement, we have been inspired by a number of other agencies. We have seen that the fine-driven approach did not bring much benefit. We have seen that a responsive regulation has proven to be more advantageous, both for entities under regulation, as well as for data subjects. From the very beginning, we started with the educational activities and started already to have conversations with a number of organizations. When somebody reports an incident, we usually work together with the organization to, first of all, solve the problem. And this is what we have been doing through our activities. Among them, we also have consulted, gotten in touch with other government entities. For example, Senacom, the Federal Police, CADE, the Prosecution Office, and these have managed to get more efficient and faster results to protect the population as a whole. On the 1st of August, when sanctions started, the capacity to sanction started from ANPD, a lot of companies were afraid that we were sitting back with a book of fines to start just signing them off. Companies will have a timeline to adapt to the law. There may be provisional suspension of operations in the data protection area. Data protection incidents that may hinder the reputation of a number of companies. When there's an event, there will be dissemination of that event for the interest of society. The conversation that we have held with organizations, DPOs, have had a positive impact on understanding. Our agency wants to disseminate transparency, wants to speak to everyone, and it's very concerned in showing that data is important. It's precious to data subjects, and we are not here to hinder data use, but just make sure that data is increasingly used in a responsible manner by everyone. We want to show that data that doesn't add any value to the companies, there's no point keeping them. It's just incurring into useless risk. Organizations should always be asking themselves, what data do I need to keep? They need to be aware that they have a responsibility over the use of data. And technology and digital transformation is actually here in order to help everybody. It's very important for companies to apply constructive governance in their structure, making everyone embrace the cause of data protection. Very often, data leaks happen as a result of an internal flaw, sometimes a person who's not very happy in the organization. So governance is highly relevant, and the role of DPOs is highly important at this time. The challenges the ANPD is faced with internally is to make the authority robust, sound. We act in many areas. Other agencies are focused on sectors, health, telecommunications. We act in all sectors. All companies have a digital or non-digital database, but by having database, they incur in responsibility, and our actions and our ombudsman has been working in a very assertive way. Any user, data subject, walks into a supermarket, sees a camera, and the data subject will have the right to challenge. So even the definition of data subject rights have to be worked upon at this point. Our standard and enforcement team, the governor general, our participation in this event. Fabricio, for example, has 2 people working with him, and they have to tend to a very high demand. So this is what we have tried vis-a-vis the government, to show the relevance of our work, to show the work we have accomplished so far, and what we need to accelerate this process. So ANPD has to be sound. The change in our legal form that is established under the decree, which was a provisional situation of up to 2 years, becoming then an independent agency in the future is very important. And we have worked on this. We have submitted a proposal to the Ministry of Economy. And with this, our agency is going to have a team that is as efficient as it is today, but it's going to be sounder. And it will make it possible for us to provide an immediate, efficient response to any reports of events that our site and ombudsman receive in the agency. Felipe, I think the main thing today is going to be our conversation, and then by Q&A after the presentations made by the speakers. I am available for that, and I would like to once more thank you for the opportunity of participating in this event, and to greet everyone that is listening to us. We know that there are many people who are concerned with data protection. Thank you so much.
Presidente Valdemar, muito obrigado pelas suas palavras que muito nos tranquilizam.
Thank you for your words that are very reassuring in terms of the steps being taken by your entity. I also would like to congratulate you for the excellent work, because there's so much to be done that I believe that the easiest way would be to replicate a model from another agency or another country and see how it works. But ANPD opted not for the easiest path, but rather to gather information, to hear what different sectors are saying, and adapt this entity to our reality. So I'd like to congratulate you for your vision in terms of what has been done. Thank you. Next in our panel, I will give the floor to Dr. Isabella and Dr. Fabricio and Dr. Renata. Dr. Renata will be the moderator. Dr. Renata is the coordinator of the LGPD course that is being offered. And this is precisely an initiative to promote this topic. So Dr. Isabella Maiolini, you have the floor. She has a degree from the IDP Institute from Brasilia. She also has a degree from the University of Brasilia. She is the current coordinator of standardization at ANPD. Thank you, Felipe. I haven't got my PhD yet, so I'm working. I'm doing my graduate work, but I still have a few years to go. So thank you so much, Felipe. Thank you, ABPI, for this invitation. This panel is extremely timely. As it was said, this is a hot topic right now. People are wondering and asking how this is going to work, how enforcement is going to be applied, how everything was built to get to this final result. So it's very important that we communicate with society. We've tried, and I can say on behalf of my area, we've tried to engage in a very healthy dialogue with society. We set meetings with all those who are interested in discussing with us. So thank you. It's very timely. And let me greet the other participants in this panel, my colleagues, my boss, President Valdemar, my colleague Fabricio, who was in the past in the same unit where I am, and we've worked together, and Dr. Renata. I was very honored to be a member of this panel. And before I say anything else, a disclaimer. Of course, everything that I will say here reflect my own view. And we have here the president of my agency, so I couldn't talk on his behalf. And I have a brief presentation just to highlight a few aspects. Let me share the screen with you. Since I cannot see you right now, if somebody can let me know if you are able to see the screen, if it's being shared.
Foi?
Sim.
Agora sim, perfeito.
Okay, it's working now. But we see two, yeah, okay, now it's the way it should be. So this is a hot topic, and it's a priority. And among the main points, we have this minutes of the resolution on the enforcement of the ANPD sanctioning process. And I think maybe the best way to address this is talking about the regulation process. When we discuss with society, we feel that there are many gaps in terms of understanding the process. And we've tried to provide a better view of how this process works through decree number 16. There were questions, for example, what does NPD consider as a subsidy collection? Do we have to submit everything in writing? So these are simple questions that were answered once this decree was published, and it addresses the agenda, the regulation project, the impact analysis, internal consultation, consultation with society, legal analysis, deliberations from the director, and evaluation. So we were following this procedure, going through the different phases, and specifically in terms of monitoring and enforcement. This was established in December. And the first topic that was raised was precisely a norm that would deal with monitoring and enforcement in such a way that we would not repeat past mistakes of other entities, because we did not have the time to incur in any mistake. So this was a priority that was included in our agenda. It was published in January this year. So mandatorily, this regulation should become effective. And we had the opening of the project. And as we discussed the norm, we thought about something which is based on a command and control scheme, and Fabrício will be able to explain it better. And we asked ourselves, what do we expect exactly? And when I say what do we expect, I'm talking about our entity as a whole. So what do we expect from ANPD in terms of monitoring and enforcement? Do we want norms to punish, or we want to solve the problem? Do we want the data protection, or we just want to have sanctions and have a very long list of processes to take care? And given the objectives, what is the best way to reach our objective? These were questions that permeated our discussion. And for that purpose, we noticed that we had to hear the academic field and other governmental agencies. Why is it important to hear other agencies? Because we do not have the time to incur in mistakes. So we had these articles becoming effective in August. We had a very streamlined team, only 3 people. And we did not want to repeat the errors of the past. And also we were worried about a very long backload of sanctions. So we were in touch with Anatel, with CVN, and more than one meeting. We had meeting of people from Senacon, professors from the UNB University, and we discussed how we could do this switching mechanism, if I may call it so, and how can we show people that another model can be implemented and present better results. So we decided on this responsive regulation, and we had the drafting of the report on the regulatory impact. And this was focused on what was responsive regulation, why was it better, what are the command and control problems, what was the experience of other agencies, what were the difficulties that other agencies faced, what went well, what went wrong, what changes were introduced in other agencies to bypass the difficulties. So the first norm was offered to public consultation, and we've talked to representatives of agencies, and they said that based on their experience, they would have about 900 contributions. But we had a surprise to see that we had more than 1,800 contributions. This was very good because we were happy to see that society was responding, and we had to, of course, incorporate contributions that were given, and we have a very streamlined team, and it's a lot of information to analyze and not to let go of good contributions that are within this very large number of responses. We had 1,016 different participants. And one aspect that I believe to be interesting, especially if we compare to other agencies and see how interested society is in this work. we had 72 individuals participating, so 62% of the total. We always have the idea that companies are going to participate more actively, but here we had 72 individuals. This was a very satisfactory surprise. We had 30 from the private sector, 10 third sector, and 4 from the public sector. So we were happily surprised. The platform also provides a distribution in terms of units of the federation. So we see that most contributions came from São Paulo, but also from the state of Rio de Janeiro, Ceará, Bahia, and the federal district. So we see that throughout Brazil, we were getting contributions. And one point that I'm very proud of in terms of the work of our team is that we have 6 people in this particular unit, and all contributions were read and analyzed. There were some which were not pertinent to our purpose, and only one was not approved. There was not, and it was a systems glitch, but it was very rewarding to have this large number of contributions. We had a public hearing during 2 days, and again, we saw a large number of people who were interested. It was transmitted on YouTube. Not all agencies do that. And I think this is a way of showing how committed we are to society and to the demands of societies. We had a YouTube chat in which we were able to clarify questions. And again, we were surprised because 264 people signed up. In reality, 76 people expressed their views. So I think that for a first step in this process, this was very rewarding. And in terms of what we were given in terms of these contributions, and I don't want to evaluate in terms of the quality, these are contributions that are being analyzed, but I can anticipate that we have major contributions in the following areas. One important topic today is the differentiated treatment for small and micro companies. And so what to expect from the law? What would be the treatment offered to such companies? Another important question that was raised was the terms was related to the data holder and to administration in terms of how it's going to be processed in different layers, and also how some of these issues are going to be treated when it comes to enforcement. And I think Fabrício will be able to explain that better. But some aspects still need to be regulated, and I hope that we'll have a decree that will give a response to society in terms of this regulation. Another aspect is related to deadlines, and this is very interesting because sometimes contributions from civil society will ask for a shorter term. When contributions come from lawyers or other professional groups, they also ask for, they do the opposite, and then they ask for a different term. So we cannot please all the segments. And of course, there's no way to do that. But one major concern that was raised, and it was a surprise, at least to me, was the need of disclosure for, and how it's going to be treated, disclosure of trade and industrial secret. And as I mentioned, another important aspect was requests in terms of detailing the norm, but not many challenges in terms of responsive model. So I think the team was able to discuss that. And when we proposed the public consultation, we did not know how society was going to respond, whether they were going to understand. And so, of course, when we present this norm, we expect it to become clear and to have certain amendments in terms of data processing, responding to the different requirements of all those who are part of this universe. But we were well understood and there was a good response. It was not a problem to present a model that is still very new to some people and still need clarification. So this was very important so that little by little we can explain to society how this is going to be implemented, how enforcement and monitoring is going to be done. And another question that I didn't talk about, but there was a great expectation and this was seen in the contributions, and this was the isometric issues, and we are working on that. And we know that if it's not a number one priority, it's going to be a number two. So this topic is being dealt by the proper entities inside our system. And I'm having difficulties here ending my screen sharing. Okay. Thank you, Isabella, for your excellent presentation. This is a model that we are very happy with. And of course, adjustments will have to be made. And certainly there is a culture change, but everything is being very transparent and dialogue is being emphasized in this culture change. The next one is Dr. Fabricio. Dr. Fabricio has a degree in law and he is specialized in public services in the area of telecommunications. He works for Anatel, where he worked for mass communication, and he is from the area of consumer relationships and also worked in terms of the right of consumer, and he is the manager of consumer rights. And he is also responsible for the responsive communication. And in addition, he is the general coordinator of the data protection general entity.
Bom dia a todos que estão nos assistindo. Eu gostaria de agradecer à ABPI pelo convite, por essa oportunidade de promover a cultura.
Good morning, everyone. I'm very happy to have this opportunity to talk about the LGPD, both for a Brazilian audience as well as for a foreign audience. As for enforcement specifically, I also brought a presentation, and I think it makes sense to consider the rationale that today we are starting data protection with a focus on the concern that could emerge as to privacy risks. And since 1990, we had an incipient attempt in the Article 43 of the Consumer Protection Code dealt with this subject 30 years ago. I remember when this was approved. So the right to see what is in the data database. So since then, we have had this concern. So this is very interesting. Brazil at the time was not so unaware of the issue. We were just focused on something else. But I want to share with you my presentation and how ANPD is going to promote changing culture and compliance. The culture aspect would be a result of enforcement. I'm just going to ask you to bear with me as I share my screen. Can you see it? Yes, we can see it. I may repeat a little bit what Isabella said. When we assumed this mission and I was still in drafting standards, we need to enforce the law by protecting Brazilians' privacy and make sure that people will have their rights observed. It is provided in the law that there will be administrative sanctioning. Working with this standard would maybe bring a limitation on the responsive approach. And then we decided that we needed to expand the scope. And then we thought of enforcement as a whole. Otherwise, we wouldn't be able to make the society aware. And we started to think of a different model that Isabella called a change in culture. It's based on zero tolerance. Either you are in compliance or you're not. And if you're not in compliance, you're going to be sanctioned. In this model, you don't have the opportunity to place the solution to the problem as the priority. As a public agency, if it's not discretionary, we have to do it. It's not a choice. But if we build a model that's going to bring an opportunity for the agency and the society to interact and avoid to get to a situation when you have a system of checks and balances where you have opportunities that people will behave well, you will have the notion then of a responsive approach. So the law brings us good signals in this sense. In a gradual enforcement, to consider the behavior of the entity under regulation when you act. So we thought we need to expand the scope and think, what does the law give us as a mission? The law talks about promoting culture. There's also the complementary law on SMEs that talks about guidance when it comes to enforcement. And I think this was a very interesting approach. So we think that LGPD intends, the idea is to monitor the whole sector. Everything that ANPD receives will be absorbed and it's going to be considered in its plan. And the idea is to be as porous, as sensitive. When I speak sensitive, I talk about to be able to perceive the messages from the civil society, from data subject and data processor. It needs to be flexible in order to be able to react to what society believes is important. And this is interesting. We used to make a very well-intentioned effort and very intense effort on a number of aspects of regulations that were not necessarily the most important for society. There was the production sector and consumer, and the regulatory agents were not so worried about what we were making efforts on. So the first thing that we thought was to be sensitive to what society is presenting to us as a problem. So there has to be this synchronicity when it comes to priorities. Our raison d'etre is to serve society. We need to be able to be reflecting what society wants. But because the model of command and control didn't really serve the purpose, let's try and adopt a responsive approach. Think of a dialogue. And in this continuous dialogue between ANPD and society, you will react in accordance to what your stakeholders reacting. If it's always responsible, well-founded, well-prepared, then you're going to think, well, this company is in good faith and I'm going to act differently compared to a company that's not prepared, that doesn't respond, that's not even concerned. This is very important to be clear to society because we want companies to opt to choose the model that they're going to look responsible. And for them to look responsible before ANP, they have to take measures. For example, they have to have a privacy policy. They have to have a responsive team. So when I tell society, I'm going to treat people who are well prepared and people who are not well prepared differently, and then this has a lot to do with a responsive approach, and that works both ways. If the organization doesn't respond, the severity and our discourse is going to be a lot stricter. This is very important that society should know. Instead of treating everyone the same way, you start treating people who respond well, and much worse, people who don't respond well. So from the onset, this is the message from the ANPD. ANPD needs to be, otherwise, if we're not responsive, we're going to stimulate bad behavior. If we are giving an initial credit to the sectors, they need to honor this by taking the right measures. Given the problem Isabella presented, we need to prepare a standard. So we have an effort to organize in a responsive approach in this gradual activity from ANPD, increasing severity and the degree of intrusion in the organization's activities. And that involves the 4 phases. Monitoring, we monitor everything, reporting incidents, representing public organizations and contributions we received in the public interest consultation. There you have reflected all concerns from citizens and society. That is going to be a part of the plan for the next cycle for ANPD. In a very practical way, if everyone in the next cycle is telling me that there is a severe problem with the exercise of the right, that the companies don't have these things available, that may be my first priority in the next cycle. So I can see this is a major gap. So companies are not placing contact channels, they are not appointing DPOs. So this is what is going to be a priority in the next semester. So that is the logic behind being sensitive. But that doesn't mean to say that I'm going to start with a book of fines and going around fining everyone. The first thing we're going to do is on the first semester of 2022, we are going to check appointment of DPOs and tools to make sure rights are respected. obviously, the next week after publication, everyone is going to run around and get to the tools and hire a tool. And then when I get there, the company has already stopped violating data subject rights. So that is the logic. When you don't focus on going around finding everyone, I'm not saying it's going to be every time, but sometimes telling people what you're going to do starts solving the problem before you actually do anything. Because the organization is not going to run the risk because we have already told what we're going to do. So they organize themselves. But that's one approach. That doesn't mean to say that's the only approach. So what have we considered when we discussed for the our enforcement model? This is something Isabella also mentioned. This idea of doing things differently was to avoid what agencies told us it was a problem. They said, well, when we didn't have this guidance and preventive approach, their tools were very limited. So we ended up creating a collection of sanctioning mechanisms that was not manageable. Even if I had 50, 60 people looking after this collection of sanctions, we couldn't manage. And when I think about that, I'm talking about the time. Time is a very important concept, but the pedagogic effect of a sanction, and I am then starting on the assumption that it does, it's going to be very important. And the responsive approach, it has to be very close to where the violation happens. Otherwise, well, pedagogists tell us, if you tell your child off a week after he did something wrong, not going to have any effect. If it takes 4 years for you to make sure that there has been a violation and you're going to sanction, the person, the DPO is changed, the data protection for irresponsible. So you're not even punishing the person who's responsible. So that person is not going to associate that sanction to the conduct. So the pedagogic effect is not going to happen. So time is of essence. So if you have a very high volume of things to process, you're not going to manage in time. We thought about that too. Very often you lose the opportunity of concentrating on the solution to the problem. So being responsive means that once you have verified there has been an event, the first thing I'm going to do is to discuss how to solve it. And then after, well, is this a violation? Yes, it's a violation. So I'm going to talk about sanctioning, and I'm going to take into account how you responded to the contact by an ANPD. If you promptly resolved, sat at the table to discuss, it's very possible that next time that you're not going to be so sanctioned because of that. That's very important to be clear. Even if every time you cooperate, you're going to be rewarded for it. Usually, execution bodies are faster than control agencies. So but the opposite is happening now. Now we have the office of the Federal Controller General saying, well, consider a responsive approach because the controlling approach is not working out. When I was at Anatel, this was very interesting. This was something that was brewing in Anatel at the time in the past. So when a control body is suggesting a avant-garde system, then the agency should actually act. So we already have this idea of a responsive approach. This is already in the internal DNA of ANPD. So we're not going to have a problem. Changing the internal culture is very important for an agency, a regulatory agency, and that's a problem we're not going to have. So what did we want for enforcement? because it's important to know where we want to get to. Well, once we detected what the problem was, the model we needed to adopt, what the concerns were, we needed to be clear, to make clear where we want to get to. So we wanted to have a complete cycle. So we start monitoring, guidelines, sanctioning, monitoring again. This is a complete cycle that is going to absorb all the input society is going to offer to it. Everything you say is going to be heard and is going to be used in favor of society. That's very important. And that should also reflect, one, that ANPD has a plan, but is still capable of responding to immediate demands. Being capable of responding to unpredicted events is very important. We are going to have a plan, but we need to be able to respond to emergency. This has to be inducive to compliance. We have to make sure that people who are doing the right thing are going to be rewarded, and who don't will be sanctioned. Then we also base ourselves in guiding and prevention. Let's say, for example, I go on the website and there is no appointed DPO on the website, but I know that DPO has been appointed. And then I send an email. Then I tell them, I cannot see on your webpage the contact of your DPO. Oh, the organization says, whoa, sorry, this was a mistake. I thought that it was important to have a sign at the door of the store, but we have published on the website. You can go ahead. So in terms of effort and cost of the state, it's nothing. It's just an email. And then everybody will know who the DPO is in that company. So then we protect the data subject in a very cheap way. So as the companies resist, I make more efforts. And obviously that cost is going to be transferred as sanction to that company. But sometimes the problem is very complex. It's so complex that the company needs to understand, sit down with us and propose themselves a solution to the problem. And why do they need to propose? Because then you're going to solve what I want at the lowest cost. Otherwise, I'm going to tell you what to do, and then I'm not going to worry about your costs. So it's very important that you're so interested as I am to resolve the problem, because that's going to happen at the lowest cost for you. So a model like this is not going to work on an environment that is not very flexible. So I have to be flexible as a regulatory agency, and that has to include some kind of discretionary capacity. And that scares any entity under regulation. They would like things to be black and white, but that's where one of the guarantees come. Our discretionary power is going to be exercised connected to the purpose of the measure. I'm not just discretionary per se. I'm going to use any instrument to guide a company as long as the purpose is to promote the culture and guide. I will have prevention measures to avoid events to happen. And then the purpose is connected to the way you act. We want to have more tools. We're not going to just use fines and sanctions. We're going to use a number of tools to promote compliance so that I can modulate my behavior according to the behavior of the entity under regulation. If one entity doesn't cooperate, I'm going to use more stricter tools and even sanctions. So the idea of balancing discretionarity with responsibility is going to work as a security guarantee for the data subject. Legal security, how are we going to do that? Predictability. monitoring and the right to comprehensive defense. Being discretionary brings a motivation for administrative acts. The challenge, I may be exercising my freedom. I am going to say a limited freedom. And you as a company are going to follow my logic and the reason why I decided to use a tool over the other. It's transparent and it's going to be auditable so people can get to the same motivations as we got to. For time's sake, I am going to wrap up to understand the logic behind the enforcement carried out by ANPD. Thank you so much, and I'm available for questions.
Que essa mentalidade de orientação e prevenção será muito efetiva.
This mindset will certainly be very effective in terms of our attempt to change the existing culture, going from a zero ground to the largest possible compliance. So I would like to give the floor to Renata, and please, those who are with us, feel free to send questions using the chat box. So Dr. Renata Lisboa, who is a lawyer, an agent in intellectual property. She is member of the Council of ABPI, and she heads a commission in the Brazilian Bar Association. Renata, so you have the floor. Good morning to all of you. First, thank you for inviting me to be in this panel that is so timely, and it's also great to have people who are working and are very knowledgeable on data privacy. I have to say at first that the president of ANPD ANDP was very encouraging when he talked about the fears that society has in terms of monitoring and enforcement. This is certainly a reason for concern in society. In terms of the new approach, which tends to be responsive and conciliatory, and we've seen that the stress in the words of the three speakers, I would like to know if there is any intention to draft a set of types to typify so that we can be sure that there will be equity and also predictability. The more we, even if you think about an active responsive system in which the norm is going to be built as we evaluate the full scenario, in spite of that, it is important that those under this jurisdiction understand and know what are the limits. So I would like to know how the agency is getting structured in this sense, and whether there is any prediction being contemplated. Isabella, since we've discussed that yesterday, I'll let you answer. Thank you, President. Yesterday, Fabricio and I talked with our council to define this model, and we have this practice every time we come to a watershed in terms of which way we should proceed. We get together and we talk. The idea is that we are going to, well, let me first ask Fabricio to correct me if I'm wrong. But the idea is to have an attribution of value to the sanctioning system. And this is also what Anatel has been doing lately. I know that, as Fabricio said, I know that all lawyers and most under the jurisdiction want a black and white definition. However, this would bring about many difficulties. And I'm going to use an argument that was mentioned yesterday. And maybe for standardization, this is important and this is very relevant. How can we typify data protection if we are under constant change? So if we have a norm and attribution of value, and just a caveat, yes, of course, certain things will have to be set in black and white, but others will have to be under a system of attribution of value. This is certainly the most appropriate. Other international agencies have adopted the same system. So our benchmark is not only Brazilian companies, and I think civil society, the legal community we are expecting them to respond to that, because of course there are very sensitive points. I don't want to anticipate what is being discussed internally, but that would be my answer so far. Just add to what Isabella said. When you talk about attributing value, what I have in mind is not to have a penal code for this type of protection. What we are considering, we haven't got to the final choice, but what we are considering is, let me give you an example. Article 18 says that those under jurisdictions are allowed to know how data is being processed. And we have a term to respond to that and provide information. So in terms of this commitment, the commitment is very clear. And we should have a formula. And let me give you a fictitious example. How many users have been reached? What is the size of the company? Did we identify bad faith or we didn't? So we can follow up on the conduct, and at the end we would have an appropriate sanction. Of course, this is not going to respond to the expectation of have very clear and very clear definitions and say, well, if I do that, the fine will be 500 reais. Our understanding is that if you have a micro company, that you have your number under the taxpayer roster, just because it is a requirement, the fine cannot be similar to that would be applied to a very large company. So if we are able to introduce proportionality in the model, this would be one possible way of dealing with that. Well, this is an opportunity for all of us. It's a different model. The agency is willing and is signaling that they are going to have a new standing. And what I tell everybody is that, and what I tell myself, is that we should follow up, we should keep informed, and we have to consider not only the expectations of our clients, but the whole legal community. Another point is exactly about the deadlines and what is expected from the agency. Today, we cannot disregard the fact that we have more and more malwares that is reaching a larger number of companies. And one of the very clear signs is that the 2-day term for communication would be reasonable. In this sense, I would like to propose this question. What type of information are you going to consider as being satisfactory? Even if the company explains that this is a preliminary information, what is expected? What is the second step to be taken? What are the measures, more objectively speaking, that is going to indicate good faith in such a short period? Because the more structured that this system is in terms of security, control, type of information, well, 2 days is not exactly a long time to provide this type of information. So I'm going to add still another question, which is the following. The agency is interested in promoting communication. The idea, the risk of having data that somehow is being exposed. Of course, if this happens, it should be communicated to the agency. But how do you consider administering, managing in terms of the number of the cases that will come to the surface? How are you going to deal with that? Isabella. Well, I think Fabricio would be more, has more expertise to answer this question. These questions are tricky, but I can answer it. Well, President, if you'd like to speak before I do. Well, let's say we had our first day, we had a data incident forwarded to us, and we were notified, and we had to be very mindful of this communication. That's why we have to hear society widely, and this is precisely what we are doing. You have the floor now, Fabricio, please. Thank you. Well, Renata, why did we set this deadline of 2 days? And to answer that, I have to say, once we have this notification, what are the actions and why this term? And let me remind you that the law is very specific. We are talking about incidents involving personal data. If it does not involve personal data, we should not, ANPD should not be notified. But let's say if a name and your taxpayer number and your mother's name has been disclosed, has been leaked, and you have to be aware of that so that you can protect yourself. You cannot protect yourself unless you know that something is happening. So one company did not take care of your data as it should have taken. So these rights of being protected and receiving damages, you can only act if you are aware of the fact that a breach has occurred. And this is something that is in the main section of the article. Another point that has to be evaluated is that the company, had the company taken the necessary measures, for example, or did they just have a post-it indicating that you may smile and laugh, but 80% of security-related problems end up being situations like this one. Non-original copy of the system, lack of updating. 80% of the problems could be avoided if we paid attention to these very simple measures. So if the company was aware of the risk and took measures to provide protection to the users, this is one situation. And has the company responded properly once the incident happens? Even if you have the state-of-the-art protection, the risk is there. It's always this competition between protection and invasion. And there are times when that person, that organization that decided to violate the law, they are ahead in terms of the technology, and this may happen. So once a breach happens, did you take care of the existing failures? Did you take measures to protect the data holders? There are certain cases, they are very symbolic. There was a situation in the United States in which the response was, listen, I can pay damages for the error that occurred. I can give you an insurance, but you can also have a system for monitoring information to make sure that this is not happening. So measures were taken to mitigate the impact for the user. So, and have these measures been taken before or after the damage, the problem happened? So I want to know if that company is well prepared and if the data holder is also aware and is also taking the proper measures so as to prevent the incident from happening again. When you talk about the preliminary actions which are required, well, our proposal is I have to know as soon as possible so as to see if there's an urgent measure associated to the company or whether that instance requires an urgent measure from ANPD or whether this that is being done has to be further extended. And a well-prepared company can already tell me what type of protection they had, to what extent they were prepared or were not prepared. And my last point, and this is based on the law, we have to evaluate and we have to have a scale. Now we have a scale that covers 3 layers. I don't want to have titles like serious, not so serious, or moderate, but we are still working on that. We are still testing the system to see if that methodology is really what we want. But we have 3 layers, and except for the very severe layers, we are sending recommendations and saying such steps should be followed and such measures have to be taken so as to avoid this from happening again. For the most severe cases, we also have recommendations. Actually, we have for the 3 layers. And why do I say that in principle, in principle, we have to find out more about what happened, because sometimes we are notified that there was an invasion, but we don't know whether personal data was involved or not. So we depend on this result. If you don't know the extent of this violation, you have 30 days to let me know and give me the full report. In very serious cases, we may tell you should hire an audit to see what happened to your system, and then you should present to us all tests that were applied to make sure that this is not going to happen again. So these would be the points in terms of security. We are daily disseminating these ideas, and I say disseminating and nurturing these ideas because our proposal is to have our algorithm in tests, and with algorithms, they're always learning something new.
Maravilha, eu acho que
Great. I think this learning process and the discussion and the creation of a culture I'm sorry we couldn't hear for a few minutes. And now my question is about crisis managing actions, contingency and continuity plans, whether they are being considered for finding solutions and for applying sanctions. Certainly, Renata, one of the points that we are very concerned with is the incident response system from companies, whether they have it or not. So this is important because it's an indication of good faith. A company that prepared for that has taken measures to be prepared, well, it's a different position from that took no measures and maybe they were unaware, maybe they were aware but decided not to really care about it. So the more prepared the company is in terms of prevention, response teams, response protocols, or to have a data impact report where risks are analyzed. I think this is important. The report on the impact in terms of data protection, this is not a requirement in the law. It's a warning. If you want to prevent problems, go ahead and apply this report because it avoids problems. Can you hear me? Because I think sometimes we are having problems. Well, the report is a suggestion. It's a warning. In the no, it's not a requirement in the law. If you have a report, you indicate what risks you are subject to. Please don't see that as a requirement. This is a suggestion to avoid problems. The law introduced this suggestion which is one way of avoiding problems. Being prepared makes sense. And let me give you an example of an extreme case. If I have company A, which is working on data protection, they have a team, they have protocols, they have their directives, how do I act with a company that have state-of-the-art protection if leakages occur? So state-of-the-art means that I cannot give a sanction to that company because they have done everything within the realm of possibility to be prepared. So to give penalties to a company is like having you're dealing with a very risky situation. You want citizens to be protected. ANPD is not going to apply penalties if all possible measures have been taken. Fabricio, thank you. Just one point about your presentation to clarify one question is about the impact report. And I was part of the technical meeting in which this was discussed and in which we saw how we could deal and address the regulation which is expected in the data protection impact assessment. You mentioned that you have to have this inspiration and then you go step by step in order to mitigate risks. If we follow the European model, this report is an in-depth report in terms of activity, high-risk activities. So the report would not cover all activities of one company, but only those that imply in a high risk. So when monitoring and enforcement comes, it would be important to see if a proper mapping was carried out by the company in a very comprehensive way. So the impact report would only be required for activities involving risk, or is there a different understanding?
We haven't really defined that, Felipe. This is an issue that is probably under Isabella's responsibility. But what can I say about it? The impact report is a moment of self-knowledge to the company. The company needs to ask themselves if for that activity it's needed to have an impact report. It's not something that you dive into a pool. What are the data we're processing? So one of the preliminary issues for the impact analysis, you have to do this for all your activities, even to decide if you need to continue to do it. So this is a self-reflection, self-knowledge exercise. Well, collect tax number for producing an invoice is not a risk, but name the team the person is a fan of, or gender, or whatever other. I mean, when you think about an impact assessment, then that's what I mean. You need to make sure that you know what you're talking about. Well, thank you so much. Given the time, I have been signaled that tabletops are about to start, so we need to wrap up this panel that has been absolutely fantastic, extremely positive to hear from ANPD, and by each one of you, the cooperative nature of agency, how important a company is for a company to work in good faith. Well, the joke we're making, you know, I'll make a miracle and bring your protection tomorrow. So that's not how it works. So I'd like to thank everyone in the panel to have dedicated time to be here, continue with us. Following the 41st International Congress of ABPI, now we move on to the tabletops. Thank you so much. Have a nice day.